Public Protector Advocate Busisiwe Mkhwebane is reported by the Sunday Times to have wanted to be allowed to help draft narrowed terms for the Commission of Inquiry into allegations of state capture for the rest of the hearings. She's also allegedly, according to that article, argued that she could have done the job at a fraction of the cost. Let's get some reaction on this now. We're joined in our Cape Town studio by retired Judge Johann Kriegler and the Chair of Freedom Under Law. Judge Kriegler, thanks so much for your time on SABC News. So the Public Protector's Office has responded to that Sunday Times article by calling it, among other things, a lie, and saying she's not trying to clip the wings of the Commission, rather pointing out things, for instance, that the scope of the inquiry was meant to be confined to the evidence contained in her reports. Let's get some reaction on that.
It's a little difficult to take the Public Protector seriously any longer. Although what she is doing is extremely serious and very, very harmful for the country. But that she could presume to prescribe to the Zondo Commission how it should do its work. And if, as reported in the Sunday Times, she saw fit to criticize the Zondo Commission's method and its staffing and its costs, it is presumption in the extreme. I believe that she is either completely out of order in terms of her belief of her own powers, or she's being disingenuous. One cannot believe that a person in that public office is doing this kind of thing at this stage.
Yeah, Judge Kriegler, what I was asking you about was a rebuttal from the Public Protector's Office, trying to caution the media against reporting certain ways and saying that although she did comment on these things, she's not trying to clip the wings. With the point of costs, the issue was raised that if it runs beyond 2020, that Judicial Commission of Inquiry into allegations of state capture, it could cost around 1 billion rand. So she's saying, or her office is saying, that they raised certain points, but the way it was reported was incorrect. Let's talk about this cost and the commission running over the time it was supposed to. If it does end up costing 1 billion rand, would it not still be worth the money to recover the unknown amount of billions that have been stolen from the South African state?
I have no idea. And I do not believe the Public Protector has any reliable idea of the costs of the Zondo Commission. But judging by what has been revealed, unearthed so far before the Commission, whatever it costs is money well spent. And if the Public Protector thinks that she can do a better job of work, one would remind her of what happened in the Frida Estina inquiry, where she managed to traverse the ground and find nothing. She is in no position to criticize. I do not believe that she knows of the funding. I do not believe that she has any basis to criticize the media for being acutely aware of her own inadequacies and her own attempts at defending herself by Stalingrad methods.
You have some very strong views on the Public Protector. You've previously spoken about her as operating as a rogue unit. You know, there is a process underway to try and remove the Public Protector. Talk to us through that.
Certainly there is a move. There's a move in Parliament. It's not yet come to fruition. We do not yet have a date for the inquiry. We also know that at the 11th hour now, the Public Protector, or at least Ms. Mkhwebane personally, has brought an application to interdict Parliament from proceeding with the proceedings against her. I do not want to comment on the legitimacy or the prospect of success of that procedure, but we do believe, we have said for some time now, that the lady is not fit for the office, and it is time that she be removed from the office. She has failed to exercise the powers that the Constitution gave her for the purposes intended by the Constitution. She's looked where she shouldn't have any business looking. She has not looked where she should have looked.
One of the concerns raised, particularly when it comes to an office such as the Public Protector, is that it's not just about the person who is currently in the position, such as Advocate Mkhwebane now, and people who have defended her have said that if it's very easy to get rid of somebody because you do not like them, it means that the actual office of the Public Protector may in turn get weakened when groups or civil society organizations don't believe that the person is doing the right work. So how do you balance that, the very important role of civil society, with ensuring that officers in certain spaces retain their impartiality?
We in Freedom Under Law believe that the protection created by Chapter 9 of the Constitution for officers such as that of the Public Protector is more than adequate, provided the people who are appointed to the position do their job conscientiously and properly. There's no reason to think that they will be removed improperly. The method that she has applied clearly shows that she is not to be trusted with the powers that have been given. The mechanism for her removal is there. The mechanism for her removal should be applied, and we believe should result in her dismissal. That doesn't mean that there's anything wrong with the Constitution. It's the people within the office that make the constitutional measures necessary.
Mm-hmm. We have a legal system that's lauded across the world for its strength and its endurance. There have been, in recent weeks, political commentary around the role of judges and the unfairness, some people believe, of judges. And there's almost what seems as though a push to start asking questions around the South African judiciary's independence as well as its impartiality when it comes to politics, former presidents and the like. What's the effect of that, and should we be at any point concerned about our judicial system and the judges that we have within it?
We should always be concerned about the perception that the public has of the judiciary. The judiciary should always be concerned at the manner in which it conducts itself. Judges are not gods, they're not angels, they're human beings. They make mistakes, and people are entitled to criticize them when they do not do their job properly. They're not sacrosanct. At the same time, however, one must remember that judges are sitting ducks. They cannot respond. They are not capable of addressing the public, and politicians should be careful not to undermine and diminish the value of the judiciary as an institution. Criticizing particular judges for particular conduct is fair enough, provided one is mindful of the fact that these persons have got a job to do. If they didn't do their job properly, the proper mechanism to correct what they have done wrong is to take them on appeal. That mechanism is there, and I do believe that at the moment when just about everything in the country is politicized and just about every political dispute is taken to court, it's inevitable that the judiciary would get involved in the fringes of political debate. It's undesirable on the one hand, on the other hand, it's unavoidable, and I think on all sides one should be careful to maintain respect for the judiciary, but at the same time restraint on the part of the judiciary for its criticism of the executive and the legislature. The three branches of government must work in mutually respectful tension with one another at all times. Politicians should know that, and judges should know that.
Thanks so much for your time on SABC News this evening. Retired Constitutional Court Judge Johann Kriegler and Chair of Freedom Under Law joining me from our Cape Town studios.